So welcome everyone. I wanted to welcome you. This is Torlin calling from, and this is Torlin from All Chicago. And I wanted to go over a few housekeeping rules with us today before we get started on the training. Two things. One, reminder, please remember to place your questions in the question pane for the presenters. We'll get to Q&A at the very end of today's presentation. And also at the very end, please complete the training feedback survey by clicking on the link that's provided in the chat. So I'm going to transition and introduce you to Gianna Baker, and she's going to walk us into our next step. Thank you.
Good afternoon. My name is Gianna Baker. I'm the co-executive director of the Chicago Area Fair Housing Alliance. And on behalf of the Just Housing Initiative Coalition, I would like to thank you for participating in our webinar on the Just Housing Amendment to the Cook County Human Rights Ordinance. Next slide. I'm joined today by my colleagues from the Shriver Center on Poverty Law, Henry Shaw and Tex Paisley, and my colleagues from the Lawyers Committee for Better Housing, Aileen Flanagan and Sally Robinson. We will talk later about our organizations and give you more perspective on our work. I just want to pause right now to reiterate some of the housekeeping that Torlin just shared. So we're going to try to spend about 50 to 55 minutes or so of this session giving our presentation. Afterwards, we're going to open up our time for Q&A. And as Torlin said, please make sure you're just sending questions in the chat, and that'll help us moderate the session. I just want to go back to, I mentioned two of my colleagues who are joining us today from the Shriver Center on Poverty Law, but there's one person that I should have mentioned too, Marie Claire Train-Leong. She's going to join us in the latter half of our session to help us with our Q&A. The Shriver Center and Marie Claire in particular have worked with communities throughout the nation who have passed ordinances similar to the Just Housing Amendment. And so she will join us so that she can help in answering the questions that you may have for us today. And just another word I wanted to provide with the Lawyers Committee for Better Housing. For those of you who are joining us as case managers, or you may be joining us as someone who may be directly impacted by the criminal legal system, the Lawyers Committee for Better Housing is a great resource for helping people in the process when there may be a situation of discrimination that occurs in the community. So now we will talk more about what we are going to present on today. So can you take us to the next slide, Torlin? Thank you. So our goals are threefold today. We want to walk you through just an understanding for the context of the law and the campaign that we led to pass it. We want you then to also understand just the basics of the new housing protections. And finally, we want to make sure that we can walk with you through this process and being a resource to you and providing best practices. Next slide.
And this is Tex, and I'll be back on in a minute, but just to sort of explain this slide, I am a lawyer with the Shriver Center, but the presentation today is not legal advice. So we will be discussing the general contours of these laws, but just as a disclaimer, we would like to make sure that if anyone has a specific question or thinks they might be impacted, to consult an attorney in order to get specific legal advice.
So this picture, and this is Gianna again, is my colleague, Maria Moon. She is the housing justice organizer at the Chicago Area Fair Housing Alliance. And I believe that her quote in this picture really is kind of a reflection of the values of the Just Housing Initiative Coalition. And specifically because in our work as a coalition, we seek to dismantle housing barriers that impact people with arrest and conviction records and their families. And we represent more than 100 organizations throughout Cook County. But all of the work that we do is truly centered on the leadership and the expertise of those in the community who are directly impacted by the criminal legal system. And so what that means is as we do this work, we ensure that as we have trainings, we want to use what Maria calls language justice. And what that is people-centered language. And so we make sure that we don't use dehumanizing language like ex-offender or ex-felon. When we talk today, as we give our presentation, you're going to hear us use language like returning citizens and directly impacted leaders and people with records. And if you take a look at the picture of Maria, you will see that she is wearing a red X on her clothes. And that red X, she asked us all to wear throughout the course of the campaign to represent how people who are directly impacted by the criminal legal system are often in our communities having an experience like they have a scarlet letter because of their record. And so what we seek to do is just, as I said before, lift up our leaders and their work. And we're really excited about this campaign that we were able to lead in the course of 4 years, because the Just Housing Amendment ensures that over 1 million residents in Cook County now have protections and cannot be discriminated against because of an arrest or conviction record. Next slide. So there was a study done recently by the Ella Baker Center that surveyed communities of color in 14 states, including Illinois. And what they did was to take a look at the cost and impact of incarceration on families. And what they found was that nearly 80% of survey respondents had been ineligible for or denied housing because of their own or loved ones' records. They also found out that 1 out of 10 survey participants reported being evicted when their loved ones returned home. And this is important as we consider the impact on families and communities in our local context. Every year in Cook County, nearly 11,000 people return home from prisons in Illinois. 62% of the men and women incarcerated in Illinois are parents of minor children. 78% of women returning to communities in Cook County report having children. What this means is that families and children are often in vulnerable situations where they experience housing instability and homelessness, whether that's living in a shelter, couch surfing, or even situations where people experience domestic violence. Next slide. Fair housing testing has demonstrated that white housing applicants and Black housing applicants with similar records are often treated differently in the rental market. And so if you take a look at the picture here, it reflects what happened in a report. So as these fair housing groups sent Black testers and white testers in the community with similar records, the Black housing testers were often told that they could not have access to the housing. Sometimes they were even discouraged from going forward in the application process. The white testers, on the other hand, were often given a fair chance. And what I mean by that is that housing providers took a look at them, not just in looking at them having a record, but they looked at them as a whole person, just as all of us have made mistakes. And they gave them an opportunity to apply for the housing and to demonstrate that they are a good renter. And so what we are seeking to do with the Just Housing Amendment, and really the spirit of the ordinance, is that every family, every individual, as they go out to look for a place to live, will have the opportunity to be given a fair shot at access to living in Cook County. Next slide. So we have some quotes here that we like to lift up that reflect what the new law means in the community and to landlords. So this first quote, Wanda, a returning citizen, says here, "I feel like I have paid my debt to society. Why do you keep holding it over my head? I'm back in the system. I can vote. I can work. I can do all those things, but find a place to live." And how I've heard some other leaders in our campaign even express this sentiment is that in having a record, they get a sentence from a judge and they serve their time. And then when they come out into the community, they end up in another situation where they're continuing to serve time. And it's like having a lifetime sentence because they're still experiencing barriers in the community as they look for a place to live. We have a quote here from Anne, who is a landlord on the South Side. And Anne was a leader in our campaign who, as a landlord, wanted to make sure that people have fair access to housing. And so this is what she says: "Keeping people with criminal records out doesn't keep our community safe. As landlords, we can help returning citizens come back to society." And finally, we have this quote here, Ron: "I always prefer if I can talk to a person, because if it's a person, you can sit down and appeal to them." And so what we want the Just Housing Amendment to do is really to provide an opportunity to start a conversation between housing applicants and landlords, and to ensure that that process, again, is just fair. Next slide.
Great, thank you, Gianna. So again, this is Tex Pasley with the Shriver Center, and before diving into the details of Just Housing Amendment, we want to kind of zoom out for a minute and talk a bit about what other legal protections there are for people in housing in general, and specifically who might have criminal records. And so I think the first laws to really be aware of are the Fair Housing Act, which many of you are probably familiar with, the Federal Fair Housing Act. And then the state of Illinois has a similar law. And then there are also additional fair housing protections in Cook County and the city of Chicago. And at the federal level, it protects against discrimination based on race, color, national origin, religion, disability, or familial status. And 4 years ago, in 2016, the Department of Housing and Urban Development published guidance that found that certain criminal records policies could be a violation of the Fair Housing Act under a theory called disparate impact. And what that means is that if there's a disproportionate effect, in this case, for example, if there's a disproportionate effect where a policy affects people of one race more than another, if there's no legitimate non-discriminatory reason for having that policy, it could violate the Fair Housing Act. So a concrete example would be the fact that non-white people are arrested at a rate disproportionate to the white population. And if a landlord had a blanket policy that denied anyone with an arrest on their record, that could violate the Fair Housing Act, because often the arrest doesn't require proof of it doesn't require a conviction or a finding by a jury that the person actually committed the crime they're arrested for. So there's very little to suggest that the policy is geared towards protecting other residents or minimizing risk, but it is discriminatory. And so there's also additional protections at the state and local levels that go beyond that. So for example, the state of Illinois does in fact prevent the consideration of arrest records as well as juvenile records in housing. And then the second thing to be aware of is sealing and expungement laws. And so these are related. And I know with the recent cannabis legislation, there's been a lot of discussion about expungement of low-level marijuana convictions in Illinois. And so but there's a technical difference in that a sealed record is one that still is on file at the court. It's just restricted from public access. Well, an expunged record is literally wiped clean from the record. So the court would not still have that record on file. I don't think it's beyond that. They're very similar in that they both are intended to kind of reduce the collateral consequences of a past criminal record, whether that be an arrest or a conviction. And there are also, again, there are protections at the state level for people, as well as in the Just Housing Ordinance for people who have these records. But it varies by state. So the expungement law for cannabis I mentioned in Illinois only applies to marijuana convictions in Illinois. If the conviction was from, for example, Indiana, Indiana has its own sealing and expungement laws. So if you run into an issue where someone might want their record to be sealed or expunged, or thinks they have a record that's sealed or expunged, you need to be very precise about what state that arrest or conviction took place in. And then I have this resource indicated on the slide, the Clean Slate Clearinghouse. I would highly recommend using that resource if this comes up. They have a very user-friendly website that explains sealing and expungement laws across all 50 states. Which can also vary depending on whether the record is an adult record or it's a juvenile record. And then finally, I'll briefly mention the Fair Credit Reporting Act is a law, as it applies to regulation of credit reports, which includes tenant screening reports. And what it does is it matters here because it regulates the accuracy of these reports. And if the person whom the report is about, so say you apply for an apartment, the landlord runs a credit report or a screening report on the applicant. The applicant should, there's certain rules regulating whether, or not whether, but when the applicant should receive a copy of that report and given an opportunity to contest any of the contents of that report in terms of whether or not they're accurate. And so I think we can go to the next slide.
So, and we can advance to the next slide. So the Just Housing Amendment makes it illegal to impose blanket criminal record bans in housing. And so what that looks like is many things. So number one, if you take a look at this slide, it means that their landlords cannot in their ads discriminate against people with records. And if you take a look at the slide, you'll see towards the end of it, this landlord says no felonies. Landlords can no longer have ads that say things like no felonies, no felony records, no criminal background need not apply, because again, that is discrimination. It also means that when a person with a record is applying for housing, landlords cannot then make that person pay an additional amount for a security deposit because they are a person with a record. And now I want to go into more details because in the law, there are specifics around what a covered criminal history looks like and the specifics of those protections. Next slide. The Just Housing Amendment prohibits housing discrimination, again, based on covered criminal history. So that means that arrests, charges, and citations, participation in diversion or deferral of judgment programs, sealed records, expunged records, juvenile records cannot be considered in the housing application process. Also, convictions that are older than 3 years old cannot be considered. There are a few exceptions. Next slide. One exception is that the Just Housing Amendment ensures, or I should say, is in compliance with federal and state law mandates that allow for denial in certain situations. So examples of that in the public housing context is that if a person has current use of illegal drugs, individuals who were evicted from subsidized housing in the prior 3 years for drug-related criminal activity. Those may be situations where a person will be denied housing in the public housing context. And then there are also lifetime bans in the public housing context. So if someone has been convicted of manufacturing methamphetamines in federally subsidized housing, or they are subject to a lifetime requirement to register for past sex offenses, those are situations, again, where a person would be excluded from the protections in the Just Housing Amendment. Next slide. Number two, a housing provider can use convictions if a person currently is required to register for past sex offenses, or a person is currently subject to a residency restriction for past sex offenses. Next slide. And then there are situations, or the Just Housing Amendment ensures that for convictions that are less than 3 years old, I'm sorry, let me back up in how I should say this. So if a person has, as we said before, convictions that are older than 3 years old, those cannot be considered in the Just Housing Amendment. In a situation where a person has a conviction that is less than 3 years old, housing providers are required to perform an individualized assessment. And what that process looks like are considering factors of evidence of rehabilitation and having a conversation with a person. to consider the context for the record. And in that process of evaluation, the landlord then has to make a decision that if they are denying a person housing, they have to do that from the context that they can show there's a demonstrable risk to personal safety and or property of others. And I'm going to turn this over to my colleagues at the Shriver Center to go into more details about that.
Sure. Thank you, Gianna. This is Henry Shaw from Shriver. And Torlin, you can go to the next slide. So in this next section, Tex and I from Shriver are going to walk through step by step how the new applicant process works. This is a walkthrough of each step. There are really 5 steps of the process if the provider chooses to run a check. And the first step is really the biggest one. The first step is what we call pre-qualification. And that after pre-qualification, the provider can run a check. But during the pre-qualification stage, which we'll go into in the next slide, there's no type of arrest or conviction history that can enter into the application process in any way. The provider can't run a check and then wait until later to use it or not. The provider can't request the check. The applicant really has to be pre-qualified before anything else can happen. So Torlin, if you can go to the next slide, we can talk about what that stage looks like. So during the pre-qualification stage, the provider must evaluate all eligibility criteria other than conviction history. So what that means is imagine the rental process or the housing application process with everything still in there except for the criminal background check portion taken out. So if there are income limits for affordability reasons in the unit, if there are limits on immigration status, if there are occupancy restrictions, if folks can't have, if you have 5 dogs, but there's a 2-pet or there's a small dog restriction on what animals can live in the building, those are the kinds of things that can be evaluated. Every single thing can be evaluated as in a normal process, except for conviction history, except for the criminal background check. And so until that evaluation is complete, sorry, if you can go back one slide, Torlin. Until that evaluation is complete, as I said, criminal history doesn't enter in any way. Not only can the provider not run that check or look at it, but also this is a time when you can't ask about criminal history. There can be no informal or formal inquiry into criminal history at this stage. And so after that pre-qualification stage happens, the provider needs to give notice to the applicant. The applicant needs to know, 1, that the pre-qualification stage is complete. And then if the provider chooses to run a background check, the applicant needs to know that that's about to happen. They need to be equipped and have all the pieces of the puzzle so that they know where their application is in the process. One important thing to note before we move on is that it's up to the provider whether they'll even run a check. We work a lot with small landlords in the Just Housing Initiative Coalition, and we talk with landlords all the time. A lot of folks trust the pre-qualification process. They trust that that's the best way to understand if someone is fit for tenancy or not, and they might not even choose to run a background check. It's entirely at the provider's discretion after the pre-qualification stage is complete, and there's nothing in state, federal, there are certain circumstances in subsidized housing, but in a lot of cases, a criminal background check is not required. So we can go on to the next stage. So once that pre-qualification stage happens, once someone has been deemed to be an eligible tenant through all other ways other than the criminal background check, the housing provider has the discretion to run a check. And you can go to the next slide. And so within 5 days of getting that check, the provider has to give the background check, a copy of the background check to the applicant. Why is this? As Gianna and as Tex touched on, the goal of the amendment is to provide a fair, transparent conversation about how conviction history can be used in an application process. The goal is not that one party, either the tenant or the provider, has all the information. So the idea of giving the copy of the background check to the applicant is that the applicant has the same exact information that the provider does. Luckily, there are multiple ways, especially during this COVID-19 crisis, that the check can be delivered. It can be delivered in person, it can be delivered by certified mail, It can also be delivered by electronic communication as long as it's date stamped. So you could send an email, you could send it via text message, really anything where you can look back, see the date, make sure that it happened within 5 days, and where you can consult it at a later time. So Tex, I believe you're next here, if you switch the slide, Torlin.
Yeah, thanks, Henry. So yeah, the next stage in the process is, and again, just as a refresher, the criminal records we're discussing here would only be those ones that are less than 3 years old or that are considered under federal and state law, as Yuna discussed. But within that, once the background check has been run, the applicant should be given an opportunity within 5 days to produce evidence in order to dispute the accuracy or the relevance of the conviction history. And so taking those terms one at a time, when we're talking about accuracy, I think that's fairly self-explanatory, but basically the tenant or the applicant should have an opportunity to say that the record is either it doesn't apply to them, it misclassifies the offense, or it could not be complete. It could, for example, there's some later disposition or deferral or diversion that kind of gives a fuller picture of what happened in the case. So any dispute of that nature would be a dispute about the accuracy, and the applicant is required to have an opportunity to provide evidence showing the inaccuracy. Next slide. And then relevance, and this is somewhat subtle distinction and that relates somewhat to the next thing I'll talk about. But with relevance, the question is whether the criminal record, which again is, for example, it's within 3 years, it's something the landlord's allowed to see. At this point, the applicant is saying that that record is not relevant to kind of the person I am now. So I think the most obvious example is some sort of rehabilitation. For example, if the record is a drug possession conviction, but the person is clean now and is rehabilitated, they're not using drugs, there's nothing about that prior conviction that really is relevant to the person they are now. So again, we have examples here of whether this is employer recommendations, vocational professional training, letters of recommendation that show, I guess in non-legal terminology, just give the applicant a chance to say that prior conviction does not reflect anything about me now. And then the next slide. And so then once the tenant the applicant has had the opportunity to contest the accuracy and relevance, if there is still at that point a record that is both accurate and relevant, the housing provider may consider that in the decision, but they have to conduct what's called an individualized assessment. And as you can see on the slide, the question is whether the history negatively impacts the person's ability to fulfill the responsibilities of the tenancy. So again, at this point, we're saying that the prior record may be relevant and may say something about who this tenant is now, but there's also, like all of us, we both have good and bad things to recommend us, and the landlord should take all of those into account and not treat someone as just their record, but really ask whether this person is a good tenant or would be a good tenant. And so again, there's a list of factors here that the landlord should consider that go into this individualized assessment. And I think, I'm sorry, I guess one last thing is that the two bottom bullet points there, that they're referring to whether the applicant has a disability. Again, going back to what we talked about earlier, some of this applies under fair housing law. As I mentioned, it protects people with disabilities, and specifically this term reasonable accommodation. Just to briefly explain that, what that means for non-lawyers is well, I guess the legal definition is that the landlord is required to make some accommodation to the person's disability, which means maybe a change in policy or regular practice. So I think in the general disability context, a really good example is if someone needs a seeing eye dog, for example, but there's a no pets policy at the apartment, making a reasonable accommodation would be allowing that person to keep a dog because it helps them to get around, and it's reasonable within the overall apartment policy. So I think in here that framework is kind of adopted where the disability might relate to the person's criminal record. So I think we can go to the next slide. And then finally, there needs to be, if ultimately the landlord decides to deny the applicant, there needs to be a written notice explaining why the denial is necessary to protect against a demonstrable risk of harm to persons and property, and then informing the applicants of their right to file a complaint with the Cook County Commission on Human Rights. So this is very important, and it's important to keep this in mind because, again, I mentioned fair credit reporting. There's also a written notice requirement there, but very often landlords do not comply. So I think we want to make sure that if people are being denied, that they're being told they are denied and they have a record of it that they can then refer to, and that will help us enforce through the Cook County Commission the spirit and the letter of the Just Housing Amendment. Next slide.
Great, thank you so much, Tex. So just to give a quick recap before we dive into these practical case studies that are drawn from some real cases here in Cook and elsewhere, I just want to go over the process one more time. So when a person applies for housing, they're first in that pre-qualification stage. So what that means is that the landlord, the provider, is going to look at all relevant information aside from the criminal background check. At that point, the provider can either choose to admit the applicant without running a check. They have that full discretion if they're not in subsidized housing, or they can choose to run a check. If they choose to run a check, they need to give notice to the applicant that they've passed the pre-qualification stage, that they've met all other relevant criteria to rent the unit or the home or whatever the case may be. And they also have to tell the applicant that they're about to run a criminal background check. Once they run that check, the provider has 5 days to give the check to the applicant. They can give them that copy through electronic mail, through email, through text. They can give it in person. They can also give it through certified mail. Within 5 days of receiving that, the applicant has time to produce evidence to dispute the accuracy or the relevance, or both, of the conviction history. And so there's an individualized assessment both in how the landlord or the provider uses the background check. And then there's also the individualized assessment if the applicant chooses to dispute of the new information that they give. They might provide a letter from an employer. They might show a rap sheet from the Chicago Police Department, for example, that shows that the information that the commercial background check pulled up wasn't entirely accurate. And within 3 days of that, and these are all on business days, within 3 days of that, the provider needs to make that individualized assessment, and they need to let the applicant know of their final decision, whether to admit or to deny. So I just wanted to give you the full rundown to pull out a little bit before we go into these case studies. Torlin, you can go on to the first case study, please. Great, so the first case study is of Candace, and I'm gonna read this because I know some folks are joining over the phone. So Candace, her partner, and their 3-year-old son are looking for housing. 10 years ago, Candace was convicted of drug possession and successfully completed her probation sentence. Since her conviction, she has completed an intensive substance abuse program and has not used drugs for several years. Days after applying to an apartment, the landlord called her to deny her application, stating that, quote, no felons, end quote, are allowed. Is this a JHA violation or not? Is this a violation of the amendment? So savvy folks on the phone, I'm sure you can tell that there are already several red flags here. There are several violations of the amendment. So starting from the top, we've learned that Candace was convicted of drug possession 10 years ago. So as we learned throughout the presentation, the only relevant convictions that can happen, that can enter into the landlord's evaluation process, are convictions that happened 3 years ago or less. So already, the provider never should have seen any sort of conviction on Candace's record. And even if the provider did see that conviction, it should not factor in any way into Candace's housing evaluation. The other thing is that the landlord has clearly established a blanket ban. What does that mean? The landlord has said flat out that no felons at all are allowed. If we remember what happens with convictions that are less than 3 years old, the whole idea is that there's an individualized assessment, that people are treated as individual human beings with complex circumstances that surround any sort of conviction history less than 3 years old they might have. And so even if Candace were arrested 1 year ago or 2 years ago, she would still have the right under the Just Housing Amendment to a full individualized assessment, to be considered as a human being looking for housing who had complex circumstances. So Torlin, you can go on to the next slide. The next slide is about Tony, and Tony is someone who's currently experiencing homelessness. He's been living on the street since 2017, and he has several arrests on his record that span the last 2 years at a pretty regular basis for offenses such as loitering, disorderly conduct, and lying down in public. It's important to note here that none of his arrests have resulted in a conviction. Tony also receives supportive services, and he has a case manager from the county health department. He applies for housing, and he receives a denial letter that lists his past arrests. Is this a JHA violation or not? In what ways does this violate the amendment? So again, if you're a canny reader here, or canny listener, you can tell that there are a few red flags. The first thing is that the only information that was pulled up on this denial letter were arrests. And as we've gone over, the only information that can enter into the equation are convictions. They're convictions less than 3 years old that after an individualized assessment are shown to have a demonstrable risk to persons or property. Arrests simply don't meet that bar. So even if he was arrested every single day over the past 2 years, if none of those things led to a conviction, they can't be used against him in a housing process. Let's imagine, just in a different case, unlike Candace, unlike that last case study, that Tony was convicted of something. Let's imagine that Tony, currently experiencing homelessness, living on the streets since 2017, had a conviction for lying down in public here in the city of Chicago and in the county of Cook. So if he had that conviction, there are a few things that might suggest that an individualized assessment would show that Tony is a perfectly fit applicant. How would that be so? So the first thing is that lying down in public is a conviction that's really related to Tony's current experiences of homelessness. If you're someone who's unhoused, if you're someone who's not living in stable shelter, you might be convicted of lying down in public simply because you need a place to sleep. The other thing is that Tony has some services that suggest that lying down in public, being convicted of that offense, isn't something he'll do if he has stable housing. Why is that? He currently receives supportive services. He has a case manager from the county health department. And he has the supports that he needs that under an individualized assessment, a landlord might very well assume that he has the supports he might need to establish a healthy life without the possibility of an arrest or conviction after getting housing. So even already, these are arrests, they're not convictions, so they can't enter into the equation under the housing amendment. But also, even if they were convictions, we have some very good reasons to think, and maybe Tony's case manager would do something like write a support letter, give the landlord a call, list out what supportive services Tony has completed, or any other programs that Tony has completed. We have reason to think that even if he did have convictions on his record in the last 3 years, that he would still be eligible for housing and he could still be a great tenant. So you can go on to the last one, Torlin, please. Our last one is Yuna. So let's talk about Yuna a little bit. Yuna is a former county employee and a youth advocate. Yuna is also a survivor of domestic violence, which the domestic violence lasted over a period of 5 years. The episodes were pretty severe. One of them resulted in her hospitalization, and she had third-degree burns as a result. After her discharge, she struggled with depression, PTSD, and drug dependency, which led to her arrest and eventual plea to possession of prescription painkillers in 2017. With a lot of support, she eventually left her abuser and lived in a shelter for a period of time. She applied for an apartment, but she was denied because of the landlord's zero tolerance policy for drug-related convictions. Is this a JHA violation or not? As with Candace, as with Tony, Yuna's case is also an example where there are really JHI violations all over the place. Let's start from the end and we'll work our way back. The first thing is that we see this, we should have a red flag fly up when we see this zero tolerance policy. So landlords cannot establish policies that bar people just because of all of a certain type of conviction. Here, the landlord has a policy that says that any person with a drug-related conviction is not fit for tenancy. Under the Just Housing Amendment, that just can't be so. Every single person has the right to have a individualized assessment that shows that demonstrable risk either exists or doesn't. And so this conviction in 2017, even if the landlord didn't have a zero tolerance policy, we have a reason to think that Yuna's conviction doesn't really relate to her ability to be a good tenant. Why is that? The first thing is that Yuna is a survivor of domestic violence. The situation in which the conviction unfolded was a situation in which drugs, prescription painkillers here, were used to cope with some really serious stuff, with being a survivor and victim of violence. The other thing is that Yuna's pattern of drug use has been changed. Yuna left her abuser. She's lived in a shelter for a while, and Yuna has a lot of support around her. She's someone who has worked through the circumstances that led to her conviction. If you were someone who was working with Yuna as a case manager, as a social worker, certain things that you could do in Yuna's case if she were turned down. It looks like she's worked for the county. It looks like she's a youth advocate. She's lived in a shelter. There might be circumstances where you could call up her former employer for a letter of support. You might write a letter of support yourself talking about all of Yuna's youth advocacy. You might pick up the phone or talk Yuna through ways to talk about her really complicated past, what she's lived through, what's happened to her, what the circumstances were around her conviction, and how she can move past that. And you might also think about ways, and this will be a good transition, to put the landlord on notice, to think about why, to help the landlord understand why the zero tolerance policy, one, is not legal. It doesn't cohere with the Just Housing Amendment rules here in Cook County, but also why a zero tolerance policy is actually not good business, right? Yuna might be a perfectly good tenant. Candace or Tony might be perfectly good tenants, and a zero tolerance policy really doesn't allow them to see that, and might actually lead to some vacancies in their units that could be avoided. So Torlin, feel free to go to the next slide, please. Great.
Thank you. I know we've covered a lot of material, and I just want to say again that our goal is to be a resource to you. As I said before, the Just Housing Initiative is a coalition that represents more than 100 organizations. And what we have done for our coalition is to try as best as we can to go out into the community and provide resources. And we know that today, most of you joining us fall into probably two categories. You may be a housing provider, or you may be in the role of being a case manager. And so we have created a packet of materials that you will receive today. One packet is specifically resources for housing providers, and that includes materials that we have gotten from the Cook County Commission on Human Rights, which they are the agency that enforces this law. And then there are some items that we've found helpful for housing providers as we've had some of our trainings. And just to give you an idea of what's in those materials, you will see that there is sample language for notices that housing providers have to give at every point of the application process. There's also a tool for individualized assessments. And that kind of will help housing providers as they evaluate an application. And so we definitely, again, want to be a resource for you. Have contact information for the Shriver Center available. We also want to provide resources to you as case managers. And in just a minute, I'm going to turn our presentation over to our colleagues at the Lawyers Committee for Better Housing. But I do want to say that we have a packet of materials available too for case managers that includes some background, again, on the law. It also has information on how to obtain a record, because it's very important that as you are working with your client, that you and your client have access to that record, so that you can deal with those issues that may come up with disputing the accuracy of the record, and even the relevancy of a record. There are also some resources. We talked earlier in this presentation about opportunities to seal and expunge records. And so you will see resources about the sealing and expungement laws in Illinois. Cabrini Green Legal Aid is a good contact that your agency should know as you work with clients in the community. And then finally, Lawyers Committee for Better Housing, they're going to share some ways that they can also partner with those of you who are case managers to provide resources on this implementation process to the law. And so now I just want to turn it over to my colleagues at Lawyers Committee for Better Housing. Next slide.
Hey, good afternoon. Thank you, Gianna. My thanks to you, Gianna, and Torlin, and Tex, and Henry, and Mary Claire, and everybody at Shriver and CAFA. This has been very informative and helpful to us to understand this. My name is Aileen Flanagan, and my colleague Sally and I are here today to introduce you all to the Lawyers Committee for Better Housing and to let you know about our role in helping the community to enforce the Just Housing Amendment that was so well described here today. So Lawyers Committee for Better Housing is a legal aid organization advocating for low to moderate income tenants in Chicago. And we've joined forces with the Just Housing Initiative to help make this ordinance work for everyone. We all know that the rights described here today are only as effective as our community's commitment to enforce them. And for this reason, LCBH is stepping forward to assist people with records to enforce these rights and to utilize the mechanisms under the ordinance. Ultimately, we hope to help everyone have access to housing without experiencing these unlawful barriers. If your clients describe that they're experiencing this type of discrimination, we'd ask you to refer them to us. We have our referral intake number here at 312-347-7600, or they can go to our chat bot at rentervention.com, which can help step them through the pre-screen process and get them to us to get the help that they need. I'd like to thank you all for helping to make affordable housing available to everyone here in our community. And just a quick reference to the handouts that we've supplied. We kind of provided a handout that shares our contact information and information just about the Lawyers Committee for Better Housing generally, and again, our location access, but also a step-by-step description about what's happening during this particular pandemic and some of the protections in place in Chicago for renters. So hopefully that can also give you a little assistance when you're guiding clients that may be experiencing housing instability right now. So I thank you very much, Gianna, for inviting Lawyers Committee for Better Housing to join your presentation today. And I invite anyone that has questions about the enforcement process to contact myself or Sally. Our email address is in the next slide. Now I turn it back over to you, Gianna.
Yes, and we are about to just start our question and answer period. And before we get started on that, I want to talk about one other resource that we have through the Chicago Area Fair Housing Alliance. We have folks who work with us who are community navigators. And what they do is to provide education and help people navigate through the application process. And so for those of you too who are case managers and you may have trainings for your clients, we would certainly love opportunities to provide trainings. We are adjusting to learning this process of doing that through webinars and not in person as we are used to doing them. But we would certainly love opportunities to provide sessions for clients and others in the community. So please let us know if you are interested in presentations. And so now with that said, we just want to take this time to answer questions that you may have. So I'm going to turn it over to Torlin to help us through the process of moderating our time now.
Okay, so Gianna, there's a question that I have. This question says, does the 3-year clock start with the date of conviction?
And the answer is yes, it does. And that was a very important process for us as we advocated for this law, that it is 3 years from the actual date of conviction.
Okay. The other question is, please clarify for me, within the past 3 years, are all felony convictions a reason to exclude or deny housing, or does the degree of the felony play a role here, such as aggravated versus non-aggravated felony, crimes of moral turpitude, etc.?
Yeah, so I hear Henry stepping in. So Henry, please go ahead.
Yeah, thank you for the questions. That's a very thoughtful one. So as we were talking about during the individualized assessment, there are a lot of things that go into that, right? So there's the recency, the severity of the conviction, the circumstances in which it happened. The nature of the conviction can certainly factor into the individualized assessment process, right? The goal of the individualized assessment is to assess demonstrable risk to persons or property. And some of the things that the questioner has astutely flagged can factor into that assessment of demonstrable risk. What I will say though, if I understood the first part of the question correctly, there can be no blanket ban. And so all convictions less than 3 years old, whether they be what in Illinois is called a class 1 felony, or whether they're what would be understood as a minor misdemeanor, those all need to have an individualized assessment that's respectful and thorough. So you couldn't say all folks with X felony are banned from housing. You need to have an individualized assessment.
Okay. So this is a statement. This says the city of Chicago states that they don't have to abide by this ordinance because it is through the county. What lease should landlords use now to house tenants without violating this ordinance inadvertently?
Well, I think Tex would be able to provide some details concerning that question. And I do see also that Marie Claire is on the line. And Marie Claire, again, is our colleague from the Shriver Center who has been leading their national work on legislation similar to the Just Housing Amendment. And I just want to pause to see if Marie Claire or Tex wanted to answer that question or provide a response to that statement.
Hi, everyone. This is Marie Claire. Thank you for having me on today. So with respect to the question about whether the Just Housing Amendment applies to Chicago, it does apply to Chicago because Chicago sits in Cook County and doesn't have a law that directly conflicts with it. So landlords in Chicago are under the same obligation to abide by the Just Housing Amendment as any other landlord in Cook County. In terms of what they should provide in their leases, right now we don't necessarily have a model lease for landlords, but I think if I were a landlord, what I would do is probably consult the materials that the Cook County and Human Rights has provided to give guidance on how to structure their tenant selection criteria and process to abide by the Cook County Human Rights Ordinance.
Okay. So there's this question that I have. If denial follows individual assessment, what recourse does the applicant have?
That's a great question. Marie Claire, can you talk about the opportunity to dispute process?
Well, so if you can repeat the question again, it sounds like the question is if denial
follows individual assessment, what recourse does applicant have?
So the landlord, the Just Housing Amendment, what it really provides for is that everyone has an opportunity, everyone who the amendment applies to has an opportunity to have an individualized assessment by the landlord. If the person is denied and for some reason the applicant is under, let me start again. If the person is denied and there's been an individualized assessment, if the applicant has reason to think that an individualized assessment actually hasn't taken place, for some reason, like if a landlord says like, no matter what happened, like we would deny you or something like that, something where there's some sort of indication that individualized assessment hasn't taken place and landlord hasn't really weighed the different factors, then I think the individual probably has an argument that the landlord has not abided by the Just Housing Amendment and could potentially make a complaint with the Cook County Human Rights Commission. I think at this point, the commission is really looking to try to have parties engage in some sort of mediation as opposed to, necessarily going into court right away. I think the main idea behind the amendment and its enforcement is trying to get people housed. But I think that's really probably the main situation where a person would have recourse. I mean, if you disagree with the decision, that's a different story, I think. But what the main thing that the Just Housing Amendment promises is that fair chance to be considered and for the landlord to look beyond the four corners of the criminal background check.
Okay, thank you.
Mm-hmm.
This is a statement, I think from one of the attendees, says Chicago's home rule states their boilerplate leases can remain the same in Chicago.
I mean, the leases, I think much of what we've talked about in terms of the Just Housing Amendment centers around the application process and what happens before somebody enters a lease. So that is one guess about the reason why the lease says that. But I would actually, we'd have to actually take a look at the lease and see what it says. But a lot of the focus on the Just Housing Amendment really looks at the application process.
Thank you. That was the last question that was posed. If anyone else has any questions, please type into the question pane. We'd appreciate it. And thank you for everyone who actually posed questions. We appreciate that as well.
And I will say, while folks are gathering their thoughts, that please feel free to reach out if you have any other questions that hit you in the middle of the night or when you're working with a client.
Gianna, I don't see any other additional questions, so I'm going to turn it back over to you.
Yeah, so then with that said, the other resource that I want you to take notice of when you get a chance to look again at our PowerPoint is that in addition to providing our contact information, we have also provided the website for the Just Housing Initiative Coalition. And if you go to that website, you can continue to get updates on the work that we are doing. And so we just, with that said, really want to thank you for taking the time to join us today. And as Henry said, please do feel free to reach out to us and we can provide more information. We'd like to thank All Chicago for inviting us to present today. Thank you.
So Gianna, I'm sorry, if you're willing to, there is a couple more questions that were posed as you were going over this information that you were sharing. Is it okay if I shared that information?
Yes, please do.
Okay, so one person posed the question, can you go over the disability conviction information, the basic info about that from that slide? Could someone touch on that again or go over the basic breakdown of that? If that could be supported, they appreciate that. And then there's two more from two other members. So I'll just stop there and kind of go from there. So I think they want a basic of the disability slide. They want a little bit of a closer basic opportunity to go over that one again. But then there's another question there that says, how do you avoid the background screening process if part of the application fee is for background screening?
Okay. And so I'm going to again look to my colleagues at the Shriver Center as the legal experts if you guys want to jump in and get us started on that question. The first question related to a person having a disability.
Sure. So this is Tex again, and I believe I spoke about that. That was included on a slide earlier. And so I guess to be clear, there's kind of two levels to the disability question. One, as I mentioned, is that disability is a protected class under the Fair Housing Act. So separate from the Just Housing Amendment, landlords have an obligation to provide what's called a reasonable accommodation to anyone with disability. And without getting into too much detail, a reasonable accommodation, the example I used is, and that you see frequently, is if the landlord maybe has a no pets policy, they might be required to make an accommodation to that policy if someone needs, for example, a seeing eye dog. But that's the Fair Housing Act in general. And then under the Just Housing Ordinance and the implementing regulations, it provides that when the applicant is a person with a disability, the demonstrable risk assessment that we talked about must be based on objective evidence and also on a conclusion that any purported risk cannot be reduced or eliminated by a reasonable accommodation. And so that language in some way mirrors the Fair Housing Act, but it's more limited in that it's applying to when the disability is sort of related to the, I guess, to the overall assessment that we're speaking of and the individualized assessment about whether the person would be a demonstrable risk. So I'm happy to follow up offline. That's in general.
I just want to say something maybe to give an example that I hear sometimes offered, and if you guys can provide like more detail on this. So an example that I hear sometimes is that as someone may be working with a client, there may have been a period of time, maybe the person has a disability that is a mental health condition. And during that period of time, and it is untreated, maybe they have sometimes when they get arrested and there are some arrests or let's say convictions specifically, so that we can talk from the context of the Just Housing Amendment, they have a conviction that may be tied to them having been untreated. I think that might be an example of where providers may be wondering if there is a possibility to then, in that situation, look at advocating for reasonable accommodation for someone, because there was some disability in that situation that a person had, or rather, I should say, there is some record that a person has that's tied to a disability maybe that was untreated.
Right. Yeah, I think that's very helpful, and that's I think a good example of why this language is included in the Just Housing Amendment. And I should note that with the example you gave, it's instructive because it touches both on the relevance determination we talked about, but also the individualized assessment. So, for example, if the criminal record is related maybe to a mental health issue that they're now receiving treatment for, the applicant could say, now that I'm receiving treatment and this is no longer an issue, this prior conviction, is not relevant to my kind of condition of the moment. And then even if it is determined to be relevant, the individualized assessment requires the landlord to account for that disability and provide a reasonable accommodation. So in the accommodation can include, for example, having a treatment plan or some protocol to reduce whatever risk the tenant might present. So I think that's a really helpful example.
Torlin, there was another question that—
There was.
Yeah.
So the question was, how do you avoid the background screening process if part of the application fee is for background screening?
Is this question from the perspective of an applicant? I don't know if the wants to clarify.
I'm not sure. I'm going to wait and see if they are going to include another part to kind of give a little bit more clarification. But there is a scenario I would like to share with you. So one of the scenarios is person states, I have a landlord who has in the past said blanket denial of anyone with criminal convictions. After this passed, I reached out to them in January to find out if they have updated their policy and got a blanket no. Do you have materials we could use to try to convince them otherwise?
So
go ahead, Gianna.
Oh, no, you can.
I mean, I think as a coalition, we have not yet developed materials. So I think we're considering helping individuals who helping to draft something right now for landlords who have pretty clear-cut violations of the Just Housing Amendment in their written policies. But I mean, it's clear from both the Just Housing Amendment and also as a matter of federal fair housing law that any landlord who is just has a blanket ban against anybody who has a record, or even if it's anyone who has a felony record, that those are not legal under both federal and Cook County law. So those I wouldn't just rely on the just housing amendment there for a policy like that. I would kind of make them make the argument that they're also violating federal law by having such a policy. And if that is something that that you're seeing, I would recommend reaching out to some of the attorneys on this call, because those cases are pretty clear-cut cases where they shouldn't be denying anyone just on the basis that they have a record.
All right. So there's some clarity to the question that was posed earlier. So the question was, how do you avoid the background screening if part of the application fee is for background screening? And the person stated yes, so that they would consider the other factors first for approval before the background.
So, you know, there is not a whole lot of, this is something that if this person wants to reach out directly, I would love to talk to that person, but there is not a lot of information about an application fee under the Just Housing Amendment, except that before the landlord can accept the application fee, they have to provide the tenant screening criteria and some other additional information. So ideally, a landlord would not be accepting an application fee until later in the process. But this is I think a gap in the law about when landlords should be accepting application fees and whether they can cover the cost of a criminal background check. So I don't think that's providing much more clarity for the person who's asking the question. But I think, you know, you try to rely on the fact that they're not supposed to be looking at a criminal background check until later in the process, until they've determined that the applicant has met all other financial and other qualifications, and only then can they get a criminal background check. But again, if this person wants to follow up with me offline, I'm happy to do that.
Okay, thank you. So there are no other questions in the queue.
Okay, well, I think we can go ahead and wrap up our session. And
Okay.
so thank you again.
Thank you. Thanks, everyone.
Thanks so much, everyone.
Thank you.
Thank you.